Thank you to everybody for joining us. I know it's a few days before Christmas and people are celebrating various holidays. There's a lot going on. Even during COVID, there's still online shopping to do and all of that. So thank you so much for joining us. We are going to be talking about end of year gifting today. It always is a question that comes up quite often around this time where people want to make sure that it's the end of the year and that any annual gifts that they should be giving, if it will impact their estate down the line or their income taxes now during life, or what their beneficiaries need. They want to make sure that they're doing what they should be doing and what has to be done with any end of year deadlines. And so that is what we're going to be addressing today. As always, we'll be touching on a few different ideas of the type of gifting that can be done and some of the reasons you may want to partake in that type of gifting and reasons you may not want to. None of this is meant to be individualized advice for any of the attendees on the webinar, but it's more meant to give you some ideas to go back and speak with your own advisors about, your own attorney, accountants, financial advisors, and figure out what, if any, gifting is the proper gifting for you, given your goals and your assets. And so that is what we're going to dive into today. I'm going to start with a little primer about estate taxes and gift taxes, both on the federal level and on the state level, so you have an idea of what we're talking about when we talk about making gifts and why we might make those gifts. A lot of people make gifts for tax purposes. In 2020, the lifetime exemption on the federal estate tax limit is $11.58 million. That is going to go up to $11.7 million in 2021, so by a small amount. And that law is set to sunset for those that die in after 2025. So starting in 2026, that number is going to sunset back to 5 million indexed for inflation. And it'll be pretty close to what the New York state limit is, which this year is 5.85 million, and next year will be 5.93 million. So what does that all mean, and what are the differences, and how do they actually tax? If you die with less than the 5.85, let's take the 2020 numbers, you die in 2020 with less than $5.85 million to your name, there is no New York state estate tax because you have under the exemption amount. If you die in that same time period, that same year, 2020, with less than 5.85 million, you're obviously less than the $11.58 million federal gift tax exemption, lifetime exemption for estate taxes. So there is no tax. The difference is, if 5 years ago, you had $20 million in your name, you gave away every dime of it, New York State doesn't care. So New York State says you gave that away during life. We don't have a gift tax. Gifts during life are gifts, and we don't tax those. And so there is no gift tax in New York State. But on the federal side, unless you're giving away assets that are given gift tax free, and we're going to talk about a few ways you do that, that 20 million that you gave away 5 years ago goes towards your estate. And so if you only have an $11.58 million exemption, you're going to end up owing a tax at death if you didn't pay the estimated taxes when those gifts were made, for the fact that you gave more than your lifetime exemption. So that's a huge difference between New York and the federal regimes. In New York State, you can give it all away during life, and as long as you survive giving the gift away by 3 years, so I have to give a gift and then I have to live 3 more years, and then if I die after that point, there is no gift tax on that money given away. But there's a lifetime accumulation of gifts on the federal level. So it's a very important thing to realize. Now, I said that the law on the federal side is set to sunset in 2026. So the current law, as written, has the exemption being at the over 11 million, and then in 2026 will sunset back to 5 million index for inflation. I've already had people reach out to me and say, with the new administration coming in, is there a concern that that number could sunset sooner, could go back sooner, and even go lower than the current law says? And the answer is yes, that could happen. We have no idea if it could happen. Obviously, it's going to depend on some of these races that are coming up in January in terms of the way that Congress is going to be situated, and we'll keep an eye on that. And that may change how gifting is done down the line. It may affect things differently. But as of right now, these are what the laws are, and this is how we're advising people. So I want to give a number example just to take all these percentages and put them in perspective. The other thing I want to do before I do that actually is point out that the other big difference between the federal and New York State is that the federal is going to tax you on the amount that you're over the exemption. So if you have a $12 million estate and you're over the 11.58 million, you're taxed on that difference. In New York State, we have something called a cliff. So there's no tax until 5.85 million in 2020. And then there's a tax from 5.85 million until you hit 6,142 and a half. So basically just over 6.1. There's a tax that will be due up until that point that you're just taxed on the overage. But if you go more than 105% of that 5.85 million, and that's what gets you to the 6 million number that I said, once you go over that, New York State says you've fallen off the cliff. So there's no tax up to 585. There's minimal tax from 585 to 6142. And then once you hit that point, you fall off the cliff and you're taxed back from $1. So that tax goes from being very little to very big. I'll give you an example. If you have an estate that's $5,850,100, so just over that exemption amount, you owe $223 in estate taxes to New York State. But if you go 105% over and you're over that 6,142,000 number, your estate now owes $528,240 in taxes. So it's a very big difference. And so when you're doing your estate planning, it's not the main subject today to talk about gifting at death, but you want to be thinking about this and how close are you to that cliff? And what kind of planning do you want to do in your estate planning documents to make sure that you don't fall off that cliff if you're close to it and that your estate doesn't suffer. And so that's something you're going to want to speak with your attorney about. Another big difference between the federal government and the state is that the federal government has a much higher percentage of estate taxes, but again, they're only on the overage, where New York State's a lower amount and a sliding scale, but can be on the entire estate. And so again, the exact calculation of estate taxes is complicated because you get a credit on the federal for state estate taxes paid. So it's not just a straight percentage, but you're going to want to look into that. And when you're doing your planning and when you're trying to decide about lifetime gifting, you want to be looking at what your total estate is and what possible liability you have down the line. I have a lot of people who come in and maybe when you add up their assets, they have about $1 million. So it's a nice amount of money. They live very comfortably. They have money to leave behind, but they don't have a taxable estate. So they may not be inclined to give gifts while they're alive because they're concerned that they won't have the money for themselves. And they also don't have a benefit to do so because there's not going to be a tax on that estate when they die. Then as people get higher and higher and closer to those exemption amounts, they may want to start thinking about gifting in order to lower what their taxable estate will be at the time of their death. Another thing I want to bring up, which is a constant red herring for clients, is that especially in the Medicaid context, there are gifting penalties. There are transfer penalties for when you give assets away and then subsequently apply for Medicaid. Not going to get into the Medicaid end of it today, but many clients come to us and say, well, I gave money away. Is Medicaid going to penalize me? I only gave away the $15,000. So what are they talking about? Well, what they're saying is that New York's, the federal government says that you can give away, an individual can give away $15,000 per year per donee. So if there's 15 people standing across from me and I hand them each $15,000 this year, it is completely gift tax free and I don't have to file a gift tax return. However, if I give each of those people $20,000, I need to file a $5,000 gift tax return for each person, because for each person I went $5,000 over my exemption amount. Then at my death, all of those $5,000 gift tax returns get added up, gets added to what my estate is at the time of my death, and that's how the federal government sees how far I've come to my lifetime exemption. So the red herring portion of this is that for a lot of clients, and especially clients who are worried about going on Medicaid, they're nowhere near that federal number. And even if you don't take the 1158 as such a high number, even if you take the 5 million number, they're nowhere near it. And so they are giving away $15,000 thinking there's not going to be a gift tax, but they wouldn't have been subject to that gift tax anyway. And they are likely, if that gifting was done within a certain time of needing care through Medicaid, they are creating an issue for Medicaid eligibility. And so that's why when I started, I said that this is all just giving different ideas, but you really need to see what your estate is, what your goals are, and the best way to handle it in your individual circumstances. So as I said, the numbers in 2021 will be an $11.7 million exemption on the federal level and a $5.93 million exemption on the New York State level. They will be increasing at the turn of the year. So why gift during life? Well, we've already talked about reducing your taxable estate. That's a big reason. There's the very simple reason of many people say, well, I would rather gift to my beneficiaries while I could watch them enjoy it. And that's a nice thing. You just want to make sure you're doing so efficiently. And you may have beneficiaries that you know need it, and you know that you don't need it and you want to benefit them. And because lifetime gifting isn't penalized in New York, as I described, you could be creating a situation where you're vastly reducing the estate taxes owed at your death. The other reason for gifting, and this may be coming up if we get close to these exemptions lowering, is if you do gifting while the exemptions are high, you can lock in those gifts as exempt gifts, so that if when you die, the amount is lower, you've already gotten that money out of your estate. We are not going to get in depth on this today, but one thing I also want to talk about is especially for people who are approaching the, or somewhere between that $5 million number and the $11 million number and higher, might want to look at more extensive gifting in terms of gifting to certain types of trusts, and doing estate tax planning in that realm. And that's something else that you should be talking to your advisors and your attorneys about, to make sure that there is an additional gifting that you can do and additional planning that you can do to protect your estate from higher estate taxes. Another type of gifting that many clients ask us about are 529 plans. 529 plans are savings plans for tuition and education expenses. It used to be for college tuition, however, it's been expanded to include the lower grades as well, and also apprenticeship programs. And what you can do is, if you are giving money, it's very often a grandparent that wants to do this, that you give money to a 529 plan for your grandchild. You can be the custodian of that plan, and up to $10,000 that you put in that plan annually is deducted from your New York State taxable income. For a couple, $5,000 for an individual. You can give up to $15,000 a year to that account, and that is saving money, and it grows tax deferred, and there's no taxes paid on that money, no income taxes paid on that money when it is eventually paid out for the education expenses, the qualified education expenses of that beneficiary. In the idea of giving away more when you are when the exemptions are higher to lower your taxable estate, you can give away 5 years worth in 1 year, as long as you live the 5 years. So if I want to give $75,000 this year, as long as I live for the next 5 years, I've gotten that 75 out of my estate in this year, and it's continuing to grow tax deferred. I just can't subsequently give to that account. Again, you might want to do this in case you're giving now when the exemptions are high, and those may go down. Another thing I want to point out is that on these 529 plans, there was a law signed last year called the Secure Act, and it changed a lot of things about how our retirement plans work. And we've done seminars and webinars on that over the past year, how those retirement plans and passing them on to other beneficiaries has been changed by the Secure Act. But the other thing the Secure Act did was it made it so that you can actually repay qualified student loans up to $10,000 a year for the beneficiary of the account and their siblings out of that 529 plan. So it further expanded what that money could be used for. I just caution clients that if you are a grandparent and you own that 529 plan, that is considered your asset for Medicaid eligibility. So if you're in that group of people who is planning for Medicaid eligibility, you want to keep those 529 plans in mind. Many people think that that money, because in their head it is earmarked for the education of the beneficiary of the account, that this is not going to matter for Medicaid purposes, and it will. We have also had a case before where Medicaid looked at a 529 plan, and the grandchild was actually in college at the time we were applying for Medicaid, and the money was going from the 529 plan to the school for the tuition, and Medicaid saw that as a transfer that created a penalty for Medicaid purposes. And so you want to make sure that those 529 plans, that you're very thoughtful about who the custodian and owner of the plan are, to make sure that they're cared for. You also want to make sure that if you have those 529 plans, that there's a successor custodian on the plan, because you don't want that if the the owner custodian of the plan passes away, that you have to probate the estate for the purpose of that 529. You want it to seamlessly pass on to new owners so that beneficiary has easy access to it for their qualified education needs. For those who are charitably inclined, there's other types of planning that we also discuss when we talk about end of year or gifting while someone is living. One example that I think is really helpful for those who have very large retirement accounts that are tax deferred, and they're forced to take large income distributions that they don't necessarily need. And it ends up being a burden on the tax side for them, the income tax side, because they're paying income taxes on those distributions, is that you can take your IRA and you can give up to $100,000 a year directly to a charity. And that charity will not pay income tax, because the 501c3 charities don't pay income taxes, and you won't pay income taxes on that money when it's coming out of your account. And in the end, you've made your charitable distribution. Now, again, this is going to be for a client or an individual who's already charitably inclined, is looking for a way to give those assets to a charity, and wants to be income tax efficient because they don't need those required minimum distributions, but they're being forced to take them. It's a little different this year because due to the CARES Act and the stimulus package, individuals are not required to take their minimum distributions as they normally would be, and it's unclear what will happen in 2021 in terms of that, but certainly in other years that can be done. The other thing that I think is really interesting on that note is that the Secure Act, which I just referred to, which was signed basically a year ago, almost to the day of this webinar I'm giving right now. It was signed last December, right before the holidays, right before the close of the year. And that law said that when you give your beneficiaries at death, other than a spouse and certain various beneficiaries, if you leave, say, to your children an IRA, they're forced to take a payout of that IRA in 10 years, and they have to pay income taxes on that in 10 years. So some clients are looking for ways to reduce what is in their tax deferred money so that their beneficiaries aren't stuck with more taxes. Again, this is going to be for someone who is already charitably inclined, because in the end, you are giving that money to charity, but it's a good idea to get the assets over to the charity without there being large income taxes on your part. An important thing to remember on this is that that check has to go directly from the IRA to the charity. It has to be written out from the IRA to the charity, and it also has to be from an IRA. So if you have another type of tax deferred account, like a 403B, for example, you would first need to transfer the assets into the IRA before they then go to the charity. But that's something that you should be speaking with your advisor about if it's something that you're interested in doing. Another thing we often will tell somebody who's charitably inclined about is a charitable annuity. So this is someone who, an annuity is something that creates income over a lifetime. And a charitable annuity is often used, again, for a charitably inclined person who has an asset that has a low cost basis. So for example, if you bought Apple at $1 and now it's worth well over $100, you don't want to sell that because you're going to pay a large capital gains tax on that stock when it's sold. So what some individuals do is they take that asset, that stock, they give it to a charity and put it into a charitable annuity. So the charity sells the stock and they don't pay the tax on it because of their charitable status with the IRS. And then you can receive an annuity, an annual annuity for the rest of your life that gives you a source of income without having to deal with this stock. So those are a few ideas of the types of gifting. Now, some gifting is just a check for $300 to each of your grandchildren, or maybe it's the full $15,000. If you are a married person, you can give $30,000 because there's two. You can gift split as between two spouses. And if you have, say, a daughter who has a spouse and 4 children, you can give $15,000 to each one of them and $30,000 to each one of from you and your spouse. So there's a lot of options out there for gifting. But as we discussed today, you want to be looking at what your assets are, what your goals are, who you're looking to benefit, be it individuals, charities, or both, and how the giving of those assets will be impacted by how and when they're gifted. And then you want to come up with a plan, and it should all be done pursuant to a plan. And so if you're looking to do gifting, again, you should be checking in with your attorney, your accountant, your financial advisor, the team of individuals that advise you on these types of things. So that's what I have for today. I am going to take some questions, and I see there's some down here already, but for those of you who have to drop off, thank you so much for joining us today and for all the other webinars we've had this year. I think we can all hope for a better 2021, I should say. And it's been fantastic coming to you through the computer for this year. And I look forward to doing so again next year.
Okay, Britt, we've got a few questions here. The first one being, is the $15,000 per year per person gift amount appointment to change in the future? I'm not sure if that's...
yeah, so I don't think that, I'm trying to think of the proper way to answer this. I would say that I have not seen any proposals that have suggested a change in that amount. So it doesn't mean that it can't change, but I haven't seen it be suggested that it might. So I would assume it's going to stay that way as is. Now, I know that it has gone up over time. It was 10, it was 13. The 15 was for 2020 and remains for 2021 as well.
Thank you. Next question. Does it matter whether we contribute to a 529 plan owned by the parents or one that was established for our grandchildren in terms of tax advantage or scholarship eligibility?
It shouldn't make a difference in terms of your own tax advantage. As for scholarship eligibility, that I can't advise on, but I believe on financial aid forms, they ask about all sorts of types of potential funding for education, and so that may have an impact there.
Thank you. Is a 401k considered an IRA?
No. So a 401k and an IRA are two different types of assets. A 401k is an employer-sponsored plan. Both a 401k and a traditional IRA are tax deferred and do have required minimum distributions when an individual hits a certain age. If somebody was not yet 70 and a half at the beginning of this year of 2020, then they don't have to take until they are 72 years old based on the Secure Act. But if you are already 70 and a half and already receiving distributions, you have to continue taking those distributions. So many people, and this would be something to discuss with your financial advisor, many people choose to take their 401k and roll it over into an IRA when they change jobs rather than have multiple 401ks from multiple employers as their job cycles continue.
Thank you. What's the difference between a birthday, Christmas, or anniversary check and a lifetime gift?
So a gift is a gift. So if you're giving someone $5,000 for their birthday, $5,000 for Christmas, and $5,000 for their anniversary, if that's all in 1 year, that's your $15,000 limit for that year. Now, if you've given a lifetime gift, these are all lifetime gifts because they're made while you're alive. However, no gift tax return has to be filed on one that is under $15,000 in a year to a certain person, and therefore it is not counted towards your exemption. So when you die on the federal level, you in this year can leave $11.58 million that you've given in life or in death. And on top of that, those individual $15,000 amounts aren't even being counted.
Thank you. Can a spouse gift to their spouse?
Yes, you can give to a spouse, and there's a full marital deduction. So there are no taxes on gifts to spouses, state taxes or gift taxes.
Thank you. Does naming a beneficiary avoid estate taxes?
It does not. So if you have a home that's in your name, a retirement account that names a beneficiary, and a checking account with a joint owner, all three of those assets will be, those are your only accounts, all three of those will be added up to determine if you owe estate taxes, regardless of whether or not they need to pass through probate or not. So it doesn't avoid taxes.
If you have an account with another person, like a daughter, does that go to the estate or does it become property of the daughter?
So if you have an account that's a joint account, a joint bank account, say for example, then upon the death of one account owner, the other remains the owner of that account, and it is outside of your estate for probate purposes. However, I will point out that it is part of your estate for tax purposes if it was truly your account. We have some individuals, and for Medicaid purposes, we have some individuals who, they just put somebody on for convenience, but all of the money contributed to that account belong to the original account owner. And so that's going to come into play when determining if there are estate taxes to be paid.
Okay, thank you. That's it for the questions.
Okay, great. Thank you again, everyone, for joining us. And I hope you have a very happy and healthy new year.